Hello, everybody. Thanks for joining me. I'm Matthew Ball. I'm a property barrister here at King's, 1999 call, longer than I care to remember. And I'm going to be dealing with today's short session, mines and minerals. Now, why have I chosen to do a talk on mines and minerals? Well, in my experience, issues to do with them are becoming more and more common. That's because landowners, mineral rights holders with rights and minerals becoming more and more aware of their ability, in my experience, to use those rights to sometimes to bargain for payment from developers. Generally, I have seen more and more work coming in this area. So it's worthwhile just knowing a bit about it, I think. And this talk really is a basic talk. And it's aimed at anybody who, when they see an entry like the one I've got highlighted on the slide there, they know basically what it's about, but they might be left with an uneasy feeling that their understanding of the law isn't 100%. Okay, so let's start off with the basics. The general starting point with land, as is well known, is that the person who owns the surface also owns from the heavens down to hell. That's summed up in the Latin maxim that you can see there. I'm not going to try and pronounce that, but I'll call it the quius est solum maxim for today's purposes. So, on the face of it, the landowner owns everything down to hell. Now, it was in the Bocado SA and Star Energy case that Lord Hope helpfully reminded us all that you can't actually own right down to the centre of the earth. And as that part of the judgment there I've quoted points out, it gets pretty hot by the time you get 8 miles down and there's a lot of pressure. But the serious point to note about that case is that even things, which is what was decided in the case, is that even things which are really deep, very, very deep, in that case up to half a mile below the surface, are in the deemed possession of the surface owner and therefore can be the subject of a claim in trespass. Just a note about what we're not talking about today, the really ritzy stuff, gold, silver, oil and petroleum, and treasure is all dealt with in separate statutes. So I'm not going to deal with those. Last time I did a talk on this, actually, somebody at the end started asking me really detailed questions about some treasure. I wondered whether they'd actually found some, perhaps, in their land. But there we go, not dealing with that. What are minerals, then? Just very briefly. Well, in general, a mineral is any solid inorganic substance of natural occurrence. But in statutes and deeds, which is what we're dealing with here, that is too general a definition because it will cover it. That general idea of what a mineral is will cover anything under the ground. So when the court's looking at what a mineral is, it's normally construing a statute or a deed. And the task is just to identify what the intention was in a normal way. And there are some particular rules that the court uses to do that. So it looks at the vernacular of the mining world, the commercial world, and landowners at the time of the grant, whether the substance is exceptional in use, value, or character. And also, they'll have a look at whether the instrument that they're looking at has any powers of working the minerals, which might shed light on what the intention was, powers of entry and powers of working. That's all set out in the leading case on that, which is the Lonsdale and Attorney General decision of Mr. Justice Slade in 1982. And in fact, if you want to see how it works, there's a really recent example. It was a case decided last week. Cleveland Potash and Secretary of State for Business. In that case, the question was whether potash and salt fell within the words of a reservation in a conveyance. Oh, by the way, the pictures I've got there are some quite common minerals. I've made a note of what they are. Going clockwise, ironstone, brick shale, mudstone, and fire clay. So those are quite commonly the sorts of things you're dealing with. Don't ask me what we do with them, but they are valuable commodities. And as I say, increasingly the subject of claims or purported claims by mineral right owners. Okay, well, how are minerals held? Well, as we saw, the starting position is that the owner owns down to the centre of the earth, as far as that's possible. And that maxim, the quies est solum maxim, is reflected in the Land Registration Act 2002, Section 132, which defines land to include mines and minerals, whether or not held with the surface. So that's the starting point. The maxim that the surface owner owns down to the centre of the earth is reflected in the Land Registration Act itself. But things get a bit more complicated when there's a split in the ownership of the minerals and the ownership of the surface, or where mineral rights are granted separately. And you're never going to get anywhere in this area unless you grasp the initial fundamental distinction between the ownership of a mineral stratum itself, which is corporeal rights, actual ownership of the minerals, and by contrast, rights to take minerals out of land which still belongs to somebody else. If you want to have a look at how that works, the impact of that distinction in practice, have a look at that ARC aggregates decision of Mr. Justice Zaccaroli, now Lord Justice Zaccaroli. So just to go over that again, this is what happens when there's an exception of minerals. So when minerals are conveyed or into the ownership of someone else. If you look at my red arrow on the top there, the land is A, say, owns the surface, the grassy bit on top, and transfers the land to B, but then retains, or actually technically accepts, the minerals that are underneath my blue line that I've drawn on there. Now, in fact, of course, in reality, the line wouldn't be as neat as that. It wouldn't be like the layers of a cake, because the minerals will be in all sort of strata and veins and all over the place. But that's the basic proposition. A transfers the land to B and accepts for himself or herself the minerals. That means that A owns the minerals themselves. By contrast, when you're talking about incorporeal rights, A is the owner of the surface, but grants just a right that's in the nature of an easement, an incorporeal right to enter and to take minerals. Now, there might or might not be rights of entry. In either case, whether there's been an exception so that ownership is split, or whether there's been a grant of mere rights to minerals, that doesn't necessarily mean that the grantee has the right to enter and get them. That has to be separately provided for. And again, that's something that needs to be understood right at the outset. So there, I've got in my diagram there, you can see that there is no right to enter the surface upon a grant or of ownership or mineral rights. That has to be expressly provided for. Now, anybody who's had a look at any of this will have soon seen that mineral rights are often held by people or organisations with long historical roots, and in particular, they're very often held by manors, lordships, and estates, quite often by the church commissioners, and so on. And to understand why that is, and I think it is worth understanding why that is, I'll have to delve very quickly into a bit of English legal history. The nucleus of English rural life from medieval times onwards was the copyhold manor. And this is what explains the survival of manorial rights in minerals. So just bear with me. Copyhold was a system of tenure. It's one of those ancient systems or medieval systems, a feudal system, which existed before 1925 and the rationalisation of the law that happened then. And the basic position was this, that there was a copyhold tenant who held his land from the lord of the manor. Now, in effect, the copyhold tenant wasn't just a tenant. He was the owner of the land, really. But he held his land according to the custom of the manor. And the normal custom was for minerals to be vested in the lord, but with no right to get them. And now, gradually, copyhold estates were all turned into freeholds, and that started happening quite a lot before the 1925 legislation. It was a process called enfranchisement. But by the Law of Property Act 1922, all remaining copyholds were turned into freeholds on the 1st of January 1926. Right? Well, why does any of this matter? Why is Matthew Hall going on about this? Because, crucially, the Lord's manorial rights in the minerals were preserved by the 1922 Act. So Schedule 12, Paragraph 5, preserved the Lord's mineral rights in mines, minerals, limestone, lime, clay, stone, gravel pits, etc. Now, the view of the land registry is, if we go back to my distinction about incorporeal or corporeal rights, that these manorial rights are incorporeal rights in land. In other words, they're a bit like an easement. Manorial rights are generally not ownership itself of the minerals. They're like an easement, a profit a prondra, to take minerals out of somebody else's land. And that's relevant because it affects the way that the Land Registration Act works for minerals, which I'll come on to now. Now, where minerals are just owned as land, if you remember a moment ago, I referred to Section 132, which defines land as including minerals. There's no problem, because when a person's registered as the proprietor of registered land, that just vests the minerals in them as an estate in land. Okay. Now, apart from an estate in land, what other rights can be the subject of their own legal title, their own entry on the register, not just a notice, but their own entry? So the other rights that can be the subject of their own entry to be found in Section 3. And they are, firstly, an estate in land, which we've just dealt with. But secondly, a rent charge. Well, minerals aren't one of those. Thirdly, a franchise. They're not one of those either. And fourthly, a profit a prondra in gross. Right. So if you've got incorporeal mineral rights, i.e. just the right to go on take minerals from somebody else's land, the only way it can be registered with its own title is if it's a profit a prondra in gross. Now, a profit a prondra is a right to take something off somebody else's land. So unless there's actually a right to go onto the land to get the minerals can't be a profit a prondra, and therefore can't be registered in their own right, in their own title. And as we've seen, the normal position with regard to lords of the manor is that they weren't entitled to go onto the copyhold tenant's land to get the minerals. So therefore, manorial rights to minerals aren't normally registered with their own title. Now, at the time of the bringing in of the Land Registration Act, there was a bit of debate about this, and quite a lot of the institutional mineral rights holders tried to persuade the Land Registry that they were actually rights of ownership. And sometimes you see strange or anomalous entries where the Land Registrar has actually entered manorial rights under their own title, but it's very heavily qualified. But that's not the normal position. The normal position is if you've got any surviving mineral rights, they can't be entered under their own title. How are they protected on the register then? Well, they have to be registered by a notice. And there's another limiting factor there, because unless manorial rights or any mineral rights which could have been protected weren't protected by the 13th of October 2013, they will have lost their overriding status on any subsequent disposition of the land. So what that means is that there was a rush to register mineral rights before that date, because after that date, if there wasn't a notice on the register or registration of the minerals in their own right, when there was a transfer A to B, they wouldn't have had overriding status and would have been lost. So that's a potted account, really, of how the land registration system works. If mineral rights are ownership rights, i.e. rights to the actual minerals, ownership of the minerals themselves, they can be registered in their own title. They can only be, other rights, incorporeal rights, can only be registered in their own title if they have a right of entry, and otherwise it's a notice on the register. But if there was no notice, if there's no notice entered and there's a disposition of land after the 13th of October 2013, they lose their overriding status and they'll be defeated. So that's how it works, basically, in a nutshell. Now, I just want to have a look finally at things to look out for if you are acting for a developer who faces a mineral rights claim. Quite often these are intimated by people who purport to have some sort of manorial right. So, well, I'm the lord of the manor of such and such. You can't dig into my land because if you do, you'll be trespassing on my mineral rights, something like that. And it does actually crop up quite a bit, and particularly if you're acting for developers, or at least it's not unknown. Now, the first thing is that the law, well, as we know, anyone can buy a lordship of the manor. You don't have to inherit it, properly, so to speak. They could change hand in pubs for, a few £100 a time. And so what do you do if somebody comes along who's got one of those funny lordship titles? Well, have a look at the judgment of Lord Denning in the Corpus Christi and Gloucester case. It's an absolute gem. It sets out really nicely how a copyhold manor worked. It explains how it is that these rights came to be, manorial titles came to be bought and sold. And it says in terms that normally the manorial title will have been stripped of any property that's attached to it. So if you get a claim by somebody like purporting to have manorial rights, say, prove your title to the minerals underground. It's not necessarily the case that because you've got one of these lordship titles that you do actually, that it carries with it the rights to minerals. It may well be that it's the type that you've simply bought the title itself and the right to hold the manorial documents. So, as I say, great little summary there in that Corpus Christi and Gloucester case. Secondly, if you decide that somebody may have or does have mineral rights, what do you do about the claim that they may have? And again, I'm concentrating now really on where you're acting for a developer who's wanting to dig down into the land. You'll remember that my distinction between ownership, i.e. corporeal mineral rights, and non-corporeal mineral rights, which are just more like an easement. Only in the former case, so only if you've got ownership of the minerals themselves, can you definitely bring a trespass claim. Okay, so if you've only got a mineral right in the sense of one that's a profit a prondra, like an easement, you can't bring a trespass claim, probably, although the law's not entirely certain, but you can bring a nuisance claim. Now, why should it make any difference? Well, of course, if you've got a trespass claim, you may well be in a stronger position to say to a judge, as a mineral right holder, you can't dig down into my land. That's my mineral, and you are precluded by my ownership of that from digging a spade or a drill or whatever into it. That's just a straightforward trespass onto my property. I've got a right ask the court to restrain by way of an injunction. However, if you've only got incorporeal mineral rights and you're limited to a nuisance claim, you're in a weaker position as a mineral right holder. Because in a nuisance claim, of course, you have to prove that the interference is a substantial interference. And by the mere fact of a developer digging down with a JCB or sinking foundations into a tiny part of a vast swathe of land with all the minerals underneath it, the judge may well say, well, that's not a substantial interference at all. Drilling holes or, sinking foundations into that tiny part of it doesn't count as a nuisance. Furthermore, by the way, if you're acting for the developer, what you could say is, well, it's fine. I won't be committing a nuisance because what I'll do is I'll just keep all of the soil and the dirt with your minerals in it. I'll put them in a skip and you can come and take them if you want to. So the person who has the ownership of mineral rights is in a stronger position than the person who has mere incorporeal rights in them. So that explains, by the way, the argument in ARC aggregates that I referred to before about what rights subsisted. The claimant there wanted to try and establish that it was an exception of ownership and therefore that they would be in a stronger position to claim trespass. Oh, by the way, there's another point as well. If it's a mere manorial right, an incorporeal right, there's a little part of paragraph 5 of Schedule 12 of the 1922 Act, which says that whilst the manorial rights have been preserved, there's a proviso that the owner of the enfranchised land, i.e. that'll be your client by now, shall have the full power to disturb or remove the soil so far as is convenient for the purpose of making roads or drains or erecting buildings or obtaining water on the land. So you can rely on that as well in a manorial case. Okay, lastly, what sort of remedy is somebody going to get if they can prove their rights? Well, it's unlikely, let's face it, to be an actual injunction. If you've got planning permission to build a house and you're getting on with it and they come along, the reality is it's going to be a damages in lieu of an injunction claim. One point to bear in mind is that there's a kind of assumption that's gone round and has been accepted by nearly every surveyor that if there are damages in lieu of an injunction, that's somehow, according to this the Stokes and Cambridge measure, as they always refer to it, that it's got to be a third of development profit. And actually, that's not the case at all. If you look at Roton Park Estate, one of the leading cases on these type of damages, only 5% of the profit was awarded for breaching a restrictive covenant by way of damages in lieu of an injunction. So you'd have to look at the law on all of this. It's all summarised in that one-step support and Morris Garner case now. But bear in mind that you shouldn't just accept necessarily that somebody who comes along and you cannot prove a trespass or a nuisance is necessarily going to get or to pocket a third of your client's development profits. If you think about all of this, it's deeply unattractive. I mean, it's like the modern equivalent of Friar Tuck, sort of going around using these medieval rights to extract money out of hardworking developers who are trying to build houses and things on land. So there we are. That's my potted account. I think I'm just on time. If anyone does have any questions about what I've been rambling on about, by all means, send me an email, give me a ring. We've got a great team here, so we're always available for a chat. Next up is Rory and Harry Dyson. They're doing the new Leasehold Reform Act, which has just come into force. I need to watch this talk as well, actually, because I need to find out about it myself. Okay, good. Thanks very much for watching.